Quorum being present, the subcommittee will come to order. Without objection, all members will have 5 days to submit statements, questions, and extraneous materials for the record, subject to the length limitations for the rules. I'd like to recognize myself for 5 minutes for my opening statement. Today's hearing marks the beginning of my time as chair of the Western Hemisphere Subcommittee leadership. I'm honored to assume the chairmanship and continue the good works of the subcommittee and the full committee chairman, Ed Royce, in promoting American interests in the Western Hemisphere. This subcommittee has a long history of bipartisanship, and I look forward to continuing that tradition with my ranking member and other subcommittee members. The United States has significant security, economic, and political interests in the Arctic, Canada, Central America, the Caribbean, and South America. And I'm deeply supportive of greater U.S. engagement with our partners or friends in these places. As U.S. Southern Command Admiral Tidd testified to Congress in April, Latin America and the Caribbean is the region most connected to our own society, prosperity, and security. And we are linked by our shared values, cultures, and the rapid flow of goods, services, people, and information throughout our hemisphere. To that end, today's subcommittee is significant, with an increasing number of transnational criminal networks exploiting those links for the purposes of drug trafficking and other illicit activities. In fact, according to the UN Office on Drugs and Crime, revenue from illegal drugs may account for 50% of all transnational organized crime proceeds. These developments have a direct impact on the United States, where we're struggling with an opioid crisis that claimed more than 59,000 American lives last year and results in 91 Americans lost every day, according to the Center for Disease Control. Last year's White House National Drug Control Strategy noted significant increases in the number of Americans using cocaine, heroin, marijuana, and methamphetamine. Many of these illicit drugs are produced in foreign countries in the Western Hemisphere and are sent here to feed American demand. Illicit drugs have caused American deaths and contributed to horrible violence in our neighbors as criminal groups vie for power and control of trafficking routes. Moreover, 6 of the 10 top countries with the highest murder rates in the world this year are in the Western Hemisphere. It's imperative that we work proactively with our regional partners to fight back against the crime and violence plaguing our nations. It's against this backdrop that we meet today to conduct oversight of a key tool the United States has used since 1999 to target drug traffickers and their supporters, the Foreign Narcotics Kingpin Designation Act, or Kingpin Act. The Kingpin Act builds on Executive Order 12978, issued in 1995, which was focused solely on Colombia and was the first ever U.S. economic sanctions program administered by the Treasury Department's Office of Foreign Assets Control to address drug trafficking. In brief, the Kingpin Act blocks all property and assets of designated entities and those who support them. It prohibits U.S. transactions with designated entities. It establishes an annual process for sanctioning the most significant foreign narcotics traffickers. It increases civil and criminal penalties, and it prevents drug traffickers' spouses and children from getting visas to the United States. In 2011, President Obama issued Executive Order 13581, establishing another sanctions program targeting transnational criminal networks that threaten U.S. national security, foreign policy, or economic interests. In February, President Trump signed Executive Order 13773, prioritizing federal law enforcement responses to transnational organized crime. The State Department's Bureau of International Narcotics and Law Enforcement Affairs also publishes an annual report to Congress providing the factual basis for designations on major drug transit and major illicit drug-producing countries. The State Department designates countries that are vulnerable to money laundering by drug traffickers, and 1/3 of the countries of the primary concern are in the Western Hemisphere. These rules appear useful to U.S. objectives to counter drug flows and transnational criminal networks. However, Congress has an interest in ensuring these tools are coordinating with lasting results. Kingpin Act has been around for a long time. It has led to hundreds of individuals and entities being sanctioned. As of October, of the 110 top-tier Kingpin designation, 65 individuals and 16 organizations are connected to countries in the Western Hemisphere. Over the years, the Kingpin Act has expanded and it's now utilized globally. A lot of changing dynamics in terms of the drug cartels and different things in the global use of the Kingpin Act necessitate a review to consider lessons learned in the Western Hemisphere. And it's important to note that while the FARC and Urbanos in Colombia are both designated as kingpins, the National Liberation Front, the ELN, is not. Similarly, although MS-13 is designated under the Transnational Crime Sanctions Program, it's not sanctioned as a kingpin. Hezbollah, although listed as a foreign terrorist organization, is not sanctioned as a kingpin in any country in the Western Hemisphere. What are we losing by not including these groups in further sanctions, especially given the dangerous nexus between multinational drug operations and terror operations? Kingpin Act was recently used against the Venezuelan government officials and Mexican drug cartel operatives. How are we measuring these objectives? Since its inception, has the act led to fewer arrests coming to the United States? I look forward to hearing from our experts, and I will now yield to the ranking member on the subcommittee for his opening statement.
Well, good afternoon, and thank you for being here. I'd like to start by welcoming our new chairman, Mr. Cook. Look forward to working with you. We're happy to have you here leading the subcommittee, and I look forward to a good relationship. Today's hearing focuses on the Kingpin Designation Act, a powerful tool the U.S. has used against drug traffickers and money launderers around the world since President Clinton's administration. The Kingpin Act allows the U.S. government to target narcotics traffickers and senior members of their organizations. Dismantling these powerful organizations by going after their financial network instead of arresting low-level criminals in the streets can help take apart an organization permanently instead of trying to put a Band-Aid on an open wound. These designations have been used all over the world to target powerful drug traffickers and have helped bring down criminals who were previously thought to be untouchable. Going after groups like the Cali cartel in Colombia showed the world that no amount of money could protect a criminal network. Today, the Kingpin Act has targeted criminals all over the world, reaching from Mexico, Honduras, Colombia, to India, Afghanistan, and Lebanon. However, the process to designate an individual or an entity under the Kingpin Act can be long and murky. There are questions about how decisions are made and how the interagency process is used to coordinate these designations that frequently relate to politically sensitive foreign policies. We also need to look closely at whether these agencies have the resources they need to thoroughly investigate their targets in a timely manner. Most importantly, we must remember that Kingpin designation and all the sanctions are a tool, not an end goal. Without a clear focus or policy towards a country or criminal organization, these designations will do nothing more than stir up a few press releases and create uncertainty in already unstable countries. I am eager to listen to our witnesses today to learn how the designation process may be strengthened so that we can effectively combat criminal organizations around the world, and especially here in the Western Hemisphere. Thank you, and I yield back the balance of my time.
Thank you, Mr. Sheriff. Before I recognize our witnesses, I was going to, normally I'd like to have opening statements, but if they will indulge me, because we've got 4 witnesses here, and I have a lot of questions, and I'd rather err on the side of questions so that we can get right to the point. And before I provide you your testimony, I'm going to explain the lighting system in front of you. Very complicated. You're going to have 5 minutes. Try to stick to that. I'll try to be polite. And then, you know, you go on and on and on like some members of Congress. I'll break the gavel. But when you begin, the light will turn green. When you have a minute left, it will turn yellow. When your time has expired, the light will turn red. And then, as I said, I don't mean for you just to stop in mid-sentence, but you get the clue. Or what's it depends. If it's good stuff, yes. After our witnesses testify, members will have 5 minutes to ask questions. I urge my colleagues to stick to the 5-member rule. We don't have many here today, but I hope others will be watching this on TV. And what an important hearing this is, and they're all going to descend here, and all the seats are going to be filled. Today, we're going to be hearing from 4 witnesses. First, let me introduce Mr. Donald C. Semeski, Jr. Mr. Semeski spent 44 years in the U.S. federal law enforcement, 30 years with the U.S. Internal Review Service Criminal Investigation, and 14 with the United States Drug Enforcement Agency, 5 years as the chief of the Office of Financial Operations, and 9 years as a money laundering subject matter expert consultant. I think that adds up to about 156 years or something. God, whatever you're taking, I want some of it. Mr. Semeski, thank you for joining us today, and I'm going to introduce each panel member as we go along. So right now, unless you have any objections, you'll be recognized for 5 minutes.
Thank you, Mr. Chairman. Chairman Cook, Ranking Member Sears, and distinguished members of the House of Representatives, Subcommittee on the Western Hemisphere. First, thank you very much for allowing me to appear before you today to discuss the effectiveness of the Kingpin Act. I believe that my written statement and my testimony, as well as my answers today, will help you understand more of the tremendously effective impact that this has had on protecting the United States from the scourge of illegal drugs and the flow of money back to these organizations. And especially, and one of the things I want my testimony to really hone in on is the use of the Kingpin Act to, as an effective law enforcement tool, not just a sanctions tool, where we've been able to work very closely with the Office of Foreign Assets Control, the Department of Treasury, as part of our investigative process to target and take down simultaneously with the sanctions major foreign drug operations and money laundering operations. I will preface my remarks by saying that I'm not here as a representative of the Drug Enforcement Administration today. I'm here as a private citizen, although I did spend, as Congressman Cook highlighted, 5 years as the Chief of Financial Operations. During that tenure, I worked very closely with the Office of Foreign Assets Control and helped bring them into DEA headquarters, open up DEA data to them, and stand up a memorandum of understanding and a standard operating procedure by which that office, which is commonly referred to as OFAC, uses Drug Enforcement Administration information in their targeting and designation process. My written statement outlines the designation process, so I will not go through that, except to say that OFAC works very closely with the interagency law enforcement partners, with the Department of Defense, and with the intelligence community in targeting and vetting their designees prior to the actual designation. As I mentioned, OFAC and DEA operate under a memorandum of understanding and a standard operating procedure in accessing DEA's information and then vetting it through our agency before they can use it in their investigative reports. OFAC has a permanently assigned investigator to DEA headquarters, and also another one permanently assigned to our Special Operations Division in Virginia. As you know, I'm sure the agency also has permanently assigned investigators in both the embassy in Bogota, Colombia, and the U.S. Embassy in Mexico City, Mexico. This allows for on-the-ground investigation by those members of OFAC into foreign drug kingpins, foreign drug money laundering organizations, and it also allows them the ambassadors in those countries to get in-depth briefings on pending actions so they can make the decisions they have to on the political and financial ramifications that it's going to have on their area of operation. I've personally witnessed at many different levels in these countries the business community and the financial community's interest in the Kingpin Act and their interest in dealing with, on a day-to-day basis, the representatives of OFAC in those embassies. They are always the most sought-after people in the embassy for those sectors of, and they are at every conference, financial conference, business conference throughout Latin America. So that alone speaks to the impact of the agency. My statement talks about two examples of the effectiveness. One is, as you mentioned, Cali, Colombia. The Rodriguez-Orihuela brothers waived extradition and turned themselves over to U.S. authorities for the sole purpose of removing their families from the OFAC designation list. The other investigation is a recently concluded Rosenthal family enterprise in Honduras, which laundered drug money throughout Latin America. And that enterprise has been completely dismantled because of a joint law enforcement and sanctions activity. I will conclude with one final recommendation, and that would be that the Kingpin Act has never been included as a specified unlawful activity in the federal money laundering statute. And it would be very helpful if that violation could be included, so when drug kingpins that cannot be touched for any other reason conduct financial transactions, we can bring charges using that as the violation. Thank you, Mr. Chairman.
Thank you, Mr. Smesky. Next, let me introduce Mr. David Hall. Mr. Hall is a partner at Wigan and Dana LLP in a litigation department where he advises clients in a variety of areas, but most relevant is his expertise with corporate compliance with the Foreign Corrupt Practices Act. In 2013, Mr. Hall retired from the United States Department of Justice after 23 years as an assistant U.S. attorney. Mr. Hall, thank you for joining us today, and you are recognized for 5 minutes.
Chairman Cook, Ranking Member Saris, and members of the committee, I'm very pleased to be here. Thank you very much for giving me the opportunity to testify. I'll be summarizing my written statement. My testimony today will focus on practical sanctions issues from the ground level, in other words, from the point of view of U.S. companies who are required to comply with U.S. sanctions regimes. As you're aware, the Office of Foreign Assets Control administers a number of different sanctions programs, and all of those sanctions programs have in common that they are designed to deal with persons or entities who pose a threat to U.S. national security or U.S. foreign policy objectives. The Kingpin Act is one point of origin of many for the totality of sanctions programs administered by OFAC, and taken together, the sanctioned individuals and entities make up the specially designated nationals and block parties list, which is known as the SDN. It's a 1,000-page document that lists more than 5,000 individuals and entities. U.S. persons are generally prohibited from engaging in transactions with any of the individuals or entities on the SDN list. Today, I'll address two practical compliance challenges that face U.S. businesses in their role as gatekeepers in complying with the sanctions regimes, including those that originate with the Kingpin Act. One is OFAC's 50% rule, which I will describe, and the other is the strict liability standard that applies to all sanctions offenses. First, the 50% rule. OFAC has taken the position that any entity that's owned 50% or more in the aggregate, directly or indirectly, by one or more blocked persons is itself considered to be a blocked entity, even if that entity is not itself named on the SDN list. Now, the question is, how does a widget maker in Wisconsin deal with that? As you're aware, many sanctioned individuals, including kingpins, exert enormous effort to remain invisible, and in part to avoid U.S. sanctions. How does a widget maker crack that code? Through the 50% rule, the government has outsourced a fundamental national security function to the private sector, and this is effective, in my opinion, in reducing government accountability, but is not effective in terms of achieving the goals of U.S. sanctions programs. This is because U.S. businesses ordinarily do not have the resources and the ability to gain the kind of granular information that's necessary to understand the ownership structure of every business partner or customer. In contrast, the U.S. government does have access to that kind of information through the intel community and through law enforcement agencies. Since the government has the most reliable and efficient means of making those determinations, in my opinion, the government should do that and should list all sanctioned entities instead of leaving it up to the private sector to identify 50% partners. The second issue I wanted to address briefly is the strict liability standard. The sanctions regime seems simple. It's a list. The government publishes a list of sanctioned individuals. U.S. companies have to read that list and can't do business with those entities. Sometimes it is exactly that simple, but not always. Companies employ search protocols in order to determine whether or not they're dealing with sanctioned individuals and entities. But these search protocols often yield false positives or near positives. There are a lot of sources for these errors, including common names, names with multiple spellings, of course, misspellings, the fact that foreign language names need to be translated and are sometimes mistranslated, not to mention cultural differences in naming conventions. As a result, U.S. businesses are left with the question, how close is too close? Why is this such a big problem? Because the OFAC sanctions are administered according to a strict liability standard, which means that good faith is not a defense. So a company could be doing everything in its power to comply with OFAC sanctions, but if it accidentally violates those sanctions, then it's still liable. And the only question is, what will the penalty be? The government does take good faith compliance into account when determining penalties, but in the end, it's up to the government. In my opinion, it's not fair, but in addition, it's not an effective means of enforcing sanctions. So I have two recommendations. One is abolish the 50% rule, and the other is I think that a good faith exception to the strict liability standard should be established. This will enable the government to focus its attention on companies that are not acting in good faith, which is really the focus of any law enforcement enterprise. Thank you. Look forward to your questions.
Thank you, Mr. Hall. Next, let me introduce Dr. Emmanuel Ottolenghi. Close. This gentleman is a senior fellow at the Foundation for the Defense of Democracies and an expert at its Center on Sanctions and Illicit Finance, focusing on Iran. Sir, I want to thank you for joining us today. You are now recognized for 5 minutes.
Chairman Cook, allow me first to congratulate you on your recent appointment as the new chairman of this subcommittee. Mr. Chairman, Ranking Member Sires, members of the subcommittee, I thank you for the opportunity to testify. Hezbollah's growing involvement in transnational organized crime is a multi-billion-dollar global enterprise endorsed and coordinated by the group's top leaders, not a side business operated by greedy operatives gone rogue. Increasing quantities of cocaine invade the US and Europe from Latin America. Cocaine consumption is as much a national epidemic as opioids, and Hezbollah helps make it available to US consumers. Take the recent extradition from Paraguay to Miami of suspected Hezbollah drug trafficker Ali Shamas. Court documents show that he was part of a larger network, likely based in Colombia. At the time of his arrest, he was conspiring to export as many as 100 kilograms of cocaine a month to the US by air cargo. The US has remarkably sharp and effective tools to counteract Hezbollah's terror finance threat, though it is not always using them as vigorously as it should. To illustrate the problem, let me offer 2 examples which I discuss at length in my written statement. In 2011, the DEA indicted Ayman Juma, a Lebanese-Colombian dual national who operated a global network of companies laundering drug money for Mexican and Colombian cartels to the tune of $200 million a month. Juma worked with Hezbollah as the kingpin in one of its many global networks. A DEA official discussing the case said that Hezbollah operated like, quote, the Gambinos on steroids. As the culmination of numerous coordinated actions, which included Kingpin designations, the Juma case illustrates the effect of the Kingpin Act. Hezbollah's use of the tri-border area of Argentina, Brazil, and Paraguay, or TBA, both to launder money from illicit traffics and as a staging ground for its drug runners, shows US sanctions policy current shortcomings. In my written statement, I offer evidence of the TBA's importance to Hezbollah's global illicit trade. Lack of US sanction enforcement against Hezbollah TBA operatives since their terror finance designation in 2004 and 2006, coupled with light or no penalties for sanctioned violators, have allowed Hezbollah to strengthen its presence and increase revenues from illicit traffics, including cocaine. Unless US sanctions are constantly updated and vigorously enforced, targeted individuals and entities can soon elude them and shrug off their effects, especially if they can count on local corrupt authorities to collude with them, as it is the case with Hezbollah in the TBA. All successful cases I mention in my written statement involved a sanctions and a law enforcement component. They also relied on unprecedented intelligence sharing and interagency coordination, cooperation with foreign law enforcement and intel agencies from allied countries, and the reliance on a panoply of tools drawn from the sanctions arsenal, and in the Juma case, the Patriot Act as well. The Kingpin Act shares the same strength and limitations of other sanctions programs. When combined with other tools and leveraged as a basis for prosecution, is very effective. That's why I strongly recommend that the US administration designate Hezbollah and its senior leadership as both a transnational criminal organization and a global kingpin. US sanctions occasionally stumble upon the reluctance or refusal by regional governments to cooperate. No Latin American country has so far designated Hezbollah as a terrorist organization. Its terror financiers are not being prosecuted as such. US requests to arrest, prosecute, and extradite them might be easier if they are under Kingpin designations as well. Kingpin designations can also punish Hezbollah's enablers. Were the US to target a Latin American financial institution involved in facilitating Hezbollah's drug transactions, the impact would be devastating. Global Magnitsky Act designations should also be considered for those whom Hezbollah bribes and corrupts for access, influence, favors, and collusion in its criminal activities. Requests that the President investigate cases of corruption by foreign officials can come from chairpersons and ranking members of relevant committees in Congress. Such requests would put the spotlight on narco-terrorism's worst enablers. Kingpin designations have had salutary effects. They have named and shamed individuals, companies, and organizations, led to asset seizures, cut off terror entities from the U.S. financial systems, nudged U.S. allies and the global corporate and financial sectors into compliance. Nevertheless, there are enough countries that disagree with or disregard U.S. policy. Hezbollah operatives find a haven where U.S. sanctions alone have limited reach. And finally, Mr. Chairman, to run an effective policy, we need people and resources in place. First and foremost, the U.S. urgently needs a new DEA administrator with the vision and experience to go after transnational criminal organizations such as Hezbollah, and with the skills to coordinate government agencies, navigate bureaucracy, and build friendships and international alliances. OFAC also cannot work cases through the system without access to more resources that can enable the bureaucracy to work faster and cast its net wider. Now, these are just some of my recommendations, Mr. Chairman, and I very much look forward to your questions. Thank you.
Thank you very much, Doctor. Finally, let me introduce Mr. Eric Olson. Mr. Olson is Deputy Director of the Latin American Program and Senior Advisor to the Mexican Institute at the Woodrow Wilson International Center for Scholars in Washington, D.C. Thank you for joining us today. You're recognized for 5 minutes.
Thank you, Chairman Cook, and congratulations on your appointment, and thank you to Ranking Member Series and the other members of the committee for this opportunity to appear before you today on behalf of the Wilson Center. Given the limited time I have, I'd like to focus my remarks on the policy ideas and suggestions I set forward in my written testimony, which I have submitted for the record. To begin, I want to make clear that I believe the Foreign Narcotics Kingpin Designation Act of 1991 is one of the most important and powerful instruments the United States has in its quiver to fight organized crime and illicit financing in the region. It has been used to good effect against powerful criminal organizations and persons in countries such as Colombia, Venezuela, Mexico, and throughout Central America. Since implementation began in 2000, there have been approximately 1,800 persons and entities designated and sanctioned under the Act. The vast majority, as you've pointed out, are in the Western Hemisphere. While its use has been far-reaching, a full review of the effectiveness of this program and policy has not been conducted yet. As far as I know, neither the Treasury Department's Office of Inspector General nor the Government Accountability Office have conducted a full analysis, nor has there been a full policy review within Treasury. As far as I know, this hearing is the first attempt to look broadly at this policy and whether it is effective or not. The time is right to request a full, objective, and data-driven evaluation of the Act's effectiveness. It's been nearly 17 years since it's been first implemented, so it's time to do a cost-benefit analysis and to find out if the Act is as effective as anecdotes might suggest it is. And we all have good and positive anecdotes about its effectiveness, but it's time for a broad analysis and evaluation. Questions that must be answered include whether the Kingpin Act is effectively dismantling criminal organizations or simply splitting them up and fragmenting them. Is it having any measurable impact on accountability for criminal networks and their bosses in the region? We can point to prosecutions and convictions in the United States, but as the Honduras example that's been referred to here, and I talk about it in my written testimony, suggests, involving the Rosenthal family and Continental Bank, there really has not been much accountability for them in Honduras. Secondly, we need to use this powerful tool in a focused and careful way, seeking to avoid damage to legitimate elements of financial systems and economies in our drive to root out criminals. This is particularly the case, again, in small, weak countries such as Honduras, where sudden designations can put at risk entire financial systems and economies. The designation of the Rosenthal family in Honduras and the Continental Bank is a case in point. There's overwhelming evidence that the bank and Rosenthal family were involved in money laundering on behalf of the Cachitos criminal group. But since this was the first time a bank itself was designated under the Act, it caused near panic within the country's financial system, with many people refusing to conduct even permitted transactions with other banks for fear of somehow crossing the line and putting themselves and their business in jeopardy. And I think this refers a little bit to what Mr. Hall was talking about, this strict liability provision, good faith not being good enough. People panic and worry, not about Banco Continental, which deserved to be dismantled, but broader financial issues and questions in that country. Third, we need to use the leverage provided by the Kingpin Act to ensure that countries undertake broader reforms of their financial and judicial systems. Sanctioning individuals and entities are powerful tools, but if we can use the leverage that comes with the sanctions to push for broader reforms, greater transparency and accountability, the benefits can be immense. Fourth, we should continue investing in efforts to strengthen the capacity of financial oversight and regulatory institutions in the region. It was an open secret in Honduras that the Rosenthal family and Continental Bank were allegedly involved in money laundering activities. Everybody talked about it. It was even published in the newspaper, but nothing happened. And the Honduran National Commission for Banks and Insurance claimed to be completely surprised by this designation. So we need to do more to improve their capacity to do oversight and not just depend on our action. I know I'm out of time, but I have two really quick more recommendations. One, top-down, high-value target strategies can be valuable when confronting organized crime, but they often lead to fragmentation of criminal networks that metastasize, often forming new criminal groups or joining others in the process. And we need to view this as one amongst many instruments to attack organized crime. And finally, as this tool has become the centerpiece of the administration's strategy for countering transnational organized crime, Congress needs to make sure there are adequate resources and trained personnel to conduct the investigations and enforce the sanctions that form the backbone of these designations under the Act. Thank you very much.
Thank you very much, sir. I want to thank the panel for being very good on time. It goes fast, doesn't it? And I don't have this clock up here where I speed it up. I don't cheat, really. So anyway, I do want to compliment you. I didn't want to start off my first meeting being the bad guy. Anyway, I yield myself 5 minutes to ask some questions. And full disclosure, you know, today we had a birthday ceremony for the Marine Corps birthday. It's 242 years old, and I'm old, but I'm not that old. But anyway, it's when I was listening to the testimony, I always remember the terrorist incident in Lebanon, where my old battalion, 1st Battalion, 8th Marines, had over 200 Marines, soldiers and sailors that were killed, many more wounded. And the question of international terrorism, and a couple of the gentlemen referred to Hezbollah and its activities and spreading. I think the average when you talk to the average American on the street, they don't think of that organization being in the Western Hemisphere. They think of it as being in the Middle East, maybe North Africa or what have you. And this opens up a whole new area. And if you mentioned that, but I wanted to see if anyone was going to mention on how we can do more and suggestions on how we can implement that in terms of that organization, obviously being international and to be under the Kingpin. Anyone? Yes, sir.
If I may, thank you for your question. I would, I mean, the amount of actions that could be taken is very significant. Their presence all over the Western Hemisphere is very important and growing. Hezbollah's estimated annual operating budget is in the ballpark of at least $1 billion, and at least 30% of that comes from global illicit activities, chiefly drug trading. It is one of the principal sources of cocaine, both in Europe and increasingly in the United States, as a middleman for the cartels. That's why it is so important and directly threatening, I think, to U.S. national interests. And just one point of the many things that I would notice is that Hezbollah is active in Latin America. I mentioned the tri-border area of Argentina, Brazil, Paraguay. There is also significant activity in Venezuela, in the Caribbean islands, in Panama, and elsewhere. In many of these places, Hezbollah operatives managed to acquire, through corruption or because of lax immigration schemes, dual nationalities from those countries, which allow them to operate a lot more freely in the financial systems and in the jurisdictions in which they find themselves. So working with regional allies to look into the way that these criminals are easily acquiring citizenship in those countries would be one step forward. Thank you.
Thank you. Anyone else have a comment on that? Sir.
Yes, Mr. Chairman, I would add, first of all, I would agree with everything that Dr. Ottolenghi just stated, and also point out that when Hezbollah started to become a global organization, it already had somewhat of an infrastructure in place in the Lebanese diaspora around the world, especially in the free trade zones in Latin America. If you look at the Panama Free Trade Zone, the trade zones in Chile and Peru, all throughout Latin America, there are many, in the tri-border areas, as Doctor mentioned, many Lebanese businessmen and many that have been connected as financiers or contributors, sympathizers. So the fact that free trade zones are especially alarming in that trade goods, illicit goods, weapons of mass destruction can move through those trade zones almost unnoticed in countries with very weak infrastructure. So I think to the extent that the United States can stay on top of the trade movement throughout Latin America, that would be a recommendation.
I just want to make a comment before I recognize the ranking member. 2 years ago or a year ago, we were talking about ISIS or Daesh or ISIL, whatever you want to call them, but the fact that the corruption and the illegal smuggling of or selling oil on a black market, all those things, I think that variable was highlighted in different organizations. Task Force went after that. And I'm just thinking, hopefully we can capitalize on some of those lessons learned and use in this war against some of these other organizations. So my time has expired, and Mr. Sears, you are recognized.
Thank you, Mr. Chairman. When we designate a senior member of a criminal organization, does that shed any light on the connection between the organization and the corrupt government officials that they work with? Mr. Minsky? Looks like nobody else wants to.
Yes, Mr. Congressman Sears, it sheds light, sir, in that it helps as the information and the data is gathered and vetted through the interagency, and different agencies start taking other agencies' information and running it through their systems. The organization, the knowledge of the organization actually expands. And a lot of times those designations cause investigations or the result of investigations, which then could bring to light government corruption connected to those drug cartels or money laundering organizations.
If I may add one point which applies to Hezbollah, but I guess in general to other criminal organizations. Generally speaking, a lot of these transnational organized crime activities, chiefly the moving of illicit substances, require the complicity and the collusions of a significant number of public officials at all levels, whether it's customs or airport security officials, border police, prosecutors, judges, and organized crime across the world has the habit of buying access and influence at the highest levels of power in order to facilitate these activities. Now, corruption is rampant in Latin America, and so I think that the use of these instruments does not only facilitate the exposure of the connection between crime and power, but it also opens up the possibility that the United States can use instruments such as the Kingpin Act, such as the Global Magnitsky, to go after corrupt officials who are the enablers of crime when we cannot go after the criminals themselves.
Thank you. I'm dying to ask this question because we had a meeting with the president of Colombia, and they were working on the deal with the FARC. And I asked them, have they found any money hidden of the FARC? And he told us, no, there is no money. Does anybody, and that, or four of you, do you believe that? Or am I just being a little skeptical, I guess?
Congressman Sears, your skepticism is well placed. There is money, and we are continually working with the Colombian government and the interagency to identify it. Because the FARC is a guerrilla organization, because they do operate in the jungles and do operate with cash, it's very difficult until it hits the financial system, and then you have to find it. Their biggest expense, obviously, is their infrastructure and payment for their soldiers, and they do spend a lot of their revenues through that requirement. But we do believe there are hundreds of millions or billions of dollars in their hands, which we are constantly trying to identify.
Well, the reason I asked that question is because now these people are allowed to participate in the process of the election in the future. And quite frankly, if you had that money hidden, you can actually buy the election in the future.
I agree with you.
With all the money.
That's absolutely
So,
correct.
we win the battle and lose the war. So I was quite disappointed, with that response. And the question is, if you get on the list, how do you get off it? Mr. Olson?
I'll defer to them, because I think they know exactly much more how to do that.
Congressman, there is a process in place to be removed from the list, and OFAC has taken quite a few people off the list over the years. They have to, and typically it's going to be, there are, if I can, a Tier 1 designee is the actual kingpin. Under that kingpin are associated entities, which could be individuals or businesses. And typically it's almost impossible for a Tier 1 entity to be removed from the list. However, if an individual or a business can prove to OFAC, and they have, that they have severed ties, are no longer associated, and divested themselves of their assets in the financial, in joint financial endeavors, OFAC will remove them from the list.
Thank you.
And they do advertise that.
Thank you, Mr. Chairman. My time is up.
Thank you very much. Now going to recognize Congressman Donovan from New York.
Thank you, Mr. Chairman, and thank you for your enlightened testimony. I was a drug prosecutor in New York City for 8 years, and then I was the elected district attorney, chief prosecutor, one of the 5 in New York City before I came to Congress. Much of our success was the seizing of assets of the people who we were pursuing. I think it was I don't know, I guess it was part of their trade when they knew they were going to lose product. But it was when we took their assets that we really harmed them. How successful do you think we're being in identifying assets and in the cases seizing them with the people who are on the list that you've provided for us?
As far as the people on the list, I would say overall not very successful. I will say that when a country follows the list, in Colombia it's known as the Clinton list because President Clinton signed the initial legislation, and is also known as civil death. If you do not have access, if you're on the list, you do not have access to the financial system. And as I pointed out, the Rodriguez or Oruelas turn themselves in specifically to get their families removed from the list. At DEA, what we've done is when we investigate financial cases, we have a money flow strategy where we use money more as a weapon against the cartels than as a tool for asset forfeiture, although we do take as much money as we can identify. And that is, the money flows back towards sources of supply, the drugs flow towards the abusers. We hone our investigations, prioritize the flow of money back to sources of supply so we can identify command and control of those organizations, and it also helps us infiltrate the organizations. We mentioned, the panel members mentioned the case with Ayman Juma. That started with a DEA money laundering investigation where we provided services, we infiltrated the organization, and we ended up taking down quite a few drug traffickers, money launderers, and a bank in Lebanon.
Yeah. I would just add to that one of the reasons I think it's important, and I included in my recommendations, that we work with our partners in the region to strengthen their own capacity is that a lot of times we're dealing with attorney general's offices that are weak. We're dealing with other bank oversight commissions that are weak in the region, and it limits what we can do from a law enforcement point of view and from an effectiveness point of view. The Kingpin Act is strong and it's good. There's ways to make it better, but it's one tool amongst many. And if our partner in other countries aren't strong and capable and honest and transparent, it really weakens and undermines our own ability to go after the assets of, say, the FARC or other criminal organizations. Now, I would say Colombia has a pretty strong and improved financial system compared to other countries in the region. But nevertheless, I think this is one of the things we can't lose sight of. We have a strong tool, but sometimes the countries don't themselves. Some of the countries in Central America are just now adopting asset forfeiture laws and just beginning the process of implementing those laws. It's new to them. And so I think that we can't lose sight of that important aspect of this whole equation.
You hit on my second question. I only have a minute, so I offer to the rest of the members of the panel, how can we improve the Kingpin statute? What can we do to make it, to achieve our goals of the statute in a better way after it's been implemented and enacted nearly 20 years now?
Congressman, to me, it is a very effective statute and sanctions program. The significant way you can improve it is to add more resources to the office that administers it. They are woefully understaffed. They do not have the people to do the investigations, to work with the agencies. They do to the extent they can, and I think the resources, if you looked, and I can't tell you what they are, but I know they're very, very much understaffed right now. So I think that would go a long way. When they have the people to do the work, it's a very effective program.
I thank you all, Mr. Chairman. My time has expired. Thank you.
Thank you very much. Now I'm going to recognize the gentlelady from Illinois.
Thank you, Mr. Chair, and thank my colleague for letting me go ahead of her. Mr. Olson, you said something very interesting. You talked about we need to evaluate what we've been doing, and you talked about is it really doing what it said it's doing, or is it just serving to dismantle and fragment the bad guys, I guess? And it made me think about, I represent the Chicagoland area, and that's the same thing that's been said about the gangs, that they put the head of the gangs in jail, and now the gangs are fragmented and they're fighting for 2-block territories, and you see the chaos that's been in Chicago. But Mr. Hall, you said that the 50% rule almost guarantees that the U.S. government will fail in achieving its own goal. What would you change in order to balance the rule with the government's goals?
I would eliminate the rule in its entirety. I mean, I think what needs to happen, I mean, this blends into what we've just been talking about in terms of effectiveness, because if you think about how, in reality, on the ground, sanctions rules get enforced in the United States, it's at the business level. It's at the individual business level. And the companies that are trying to comply don't have the resources that the federal government has. And actually, they rarely understand why a particular entity is even sanctioned. All they know is that it is, and they're not supposed to deal with it. And they're trying to figure out whether the person they're dealing with, who might have a similar name or a similar business name, is the same entity. So all that ambiguity leads to ineffectiveness in enforcement. And it leads companies to a position where they're just guessing. So, you know, the more granularity the government offers business in terms of identifying sanctioned individuals and entities, the more effective the program is going to be. By just sort of issuing a blanket edict that says, you know, any entity that's 50% owned by in the aggregate, other sanctioned entities that aren't named, that's guaranteed to lead to failure. So that's what I meant by that.
Do you know how many businesses in the United States have been affected by the rule?
I'm only aware of one enforcement action under the rule, and that was about a year ago. That was in 2016. Now, I don't know why there's only been one. I guess it's not that old a rule, for one thing. But for another, you know, it makes me wonder if the government knows, if the government has spent enough time and resources figuring out the ownership structures of these 50% owned entities, and whether they know which entities are 50% or more owned by an aggregation of other sanctioned entities. It's a hard problem to solve, but it is a problem that intelligence agencies and law enforcement agencies have the resources to address.
And is there anything you would put in its place, or just forget about it?
No, I think, yeah, I would not replace it. I think the 50% rule is just fundamentally the wrong approach to tell individual businesses, you have to figure this out. We're the government. We haven't figured it out. We're going to put it on you, and then we're going to, if you make a mistake, we're going to enforce the sanctions against you on a strict liability basis, with penalties, over $250,000 per transaction. So, which adds up.
Okay. Well, I think the idea of a full and objective data-driven evaluation would be an excellent idea, since you said nothing's been done in 17 years, so then maybe that'll get to your point.
I think that's a really good recommendation. I was actually shocked to hear that. I wasn't aware of that.
Well, did you? No.
Yeah.
Oh, I didn't know if you were asking.
I'm sorry, Congresswoman. I was just going to add that I don't completely agree with Mr. Hall on that point. And if the 50% rule, I understand where he's coming from, and it's not fair to business. But also, if OFAC discovers a business that is owned 50% and it isn't on the list, if they didn't have that rule, they wouldn't be able to freeze its assets.
Okay.
Now, I do agree with the strict liability, the problem that creates for businesses, and it isn't fair. Okay, there should be some type of mitigation guidelines in place that if you truly do not know, you cooperate. Once you discover it, you self-disclose, there shouldn't be a penalty. I mean, I would add that. I don't agree with the one, but I do agree with the other.
Thank you. My time's out. Oh, thank you.
Thank you very much. I'm now going to recognize the gentleman from Florida, Mr. Rooney.
Thank you, Mr. Chairman.
Thank you, sir.
I might comment right quick about that, being a business guy. You know, there are self-disclosure procedures in the EPA and in the DOJ for companies when they discover something like a blowout preventer failure on an oil well or something, to immediately call them and say, we've got this problem, and that counts along, that gets them out of the strict liability kind of things. And might be something to think about. I'd like to ask Dr. Ottolenghi, if the ELN and the AUC are both designated foreign terrorist organizations, how come we're not doing ELN as well?
First of all, thank you for your question. I wouldn't be opposed, of course. I think that's a question for the administration, though, to be asked whether that organization should also fall under the sanctions program. If I may add a point about what you just said regarding ownership, which goes back to the activities of these organizations. By design, a lot of these companies will be opaque. There will be an intentional, deliberate obfuscation of what these organizations are about, and that usually starts with ownership. And so effective control, which requires a lot of investigation on the parts of the government to determine who really is behind these entities, I think would be the defining factor for listing and or delisting entities.
So is there anything to do with the FARC agreement and the government of Colombia's desires to make sure that thing goes, proceeds forward and are not designating ELN? Maybe for anybody that has an opinion.
Sorry, I mean, I think the designation is up to the State Department, or I mean, the Treasury Department, so it doesn't, it's not a matter of whether the Colombian government wants it or not.
Other than subtle.
Well, yeah, I mean, I think there's obviously a desire to, on the part of the Colombian government, to bring this, process to an end as quickly as possible. But I think it's up to the Treasury Department whether they would designate the ELN. And my understanding is in the past, the assumption was that ELN, while a communist guerrilla group and all that sort of stuff, they were a little bit different than the FARC. And I'm not taking sides here, but in that they were less involved with drug trafficking. And that was what the Kingpin Act was designed to deal with. Now, that could very well have changed. There may be reason to reevaluate that. All those sorts of things could be true, but that would really be, a Treasury and ultimately a State, ultimately Treasury, but State Department involvement in that assessment, and DEA, I'm sure.
Yeah, I don't know. The other question I'd like to ask Dr. Ottolenghi is about, you have a lot in your report, very great report, by the way, thank you, I'm going to save that, about the role of Hezbollah all throughout Latin America. And we figure that Iran's there everywhere Hezbollah is. I wonder if you'd like to elaborate a little bit from your experience about the role of Iran, both in backing Hezbollah in Latin America and some of the things Iran's doing independently of Hezbollah, like in Venezuela and Nicaragua.
I have to entirely second what you just said. Wherever Hezbollah goes, there is Iran, and usually vice versa. And my understanding is that in many of the illicit traffic networks that Hezbollah is running in Latin America, there is usually either a liaison person or some sort of a political commissar from Iran, and it doesn't necessarily have to be an Iranian person. It could be a Lebanese member of Hezbollah that acts as an integrated member of the Quds Force running that. So oftentimes we have to see these activities as integral to what Iran is doing in Latin America. Now, in addition to that, as you pointed out, Iran does things also independently of these traffics, and I think that Iran, in the case of Venezuela, as you mentioned, is very important, but other countries as well. Iran has been trying for almost 4 decades to gain influence across the entire region. It does so by establishing alliances with like-minded political movements, and it is very pragmatic in the way it chooses interlocutors. They can be on pretty much the whole political spectrum. It provides them with financing, with assistance, with training, in order eventually to gain access to political power if they eventually become parts of the government. It is spreading its influence through soft power tools such as cultural centers, mosques, It is recruiting and indoctrinating locals through very aggressive conversion programs. It is working with all sorts of extreme NGOs. It has used Venezuela as a platform to connect with ALBA countries' NGO across the continent. So in short, it is trying to use Venezuela and more broadly the continent as a forward operating base to expand its influence, push back against United States influence, and potentially also create operational bases to act against the United States.
Thank you, sir.
Thank you.
Thank you, Chairman.
Thank you, sir. I now recognize Congresswoman Torres from California.
Thank you, Mr. Chairman, and I believe congratulations are in order. This is your first meeting serving as the chairman of our subcommittee. Let me remind you that you have very big shoes to fill with our former chairman. We went on a trip to South America that I don't think I really understood what we were getting into, and I'm so happy that we were able to manage. Drug trafficking is obviously a very serious problem throughout our hemisphere, and our response to this epidemic has to start not just at home, but we have to look beyond that at cracking down on the illegal flow of narcotics and drugs, and we seem to be losing that battle, at least from the perspective of the Pacific Ocean and how I don't think that we have worked as closely as we could with our partners in both Central and South America to help them help us intercept the drugs that are coming north. We also need to work in the region to build up their criminal justice systems and fight corruption, working to support groups like CSIG, Innovative Approaches, which has done so much work in Guatemala. Very good work. We also need to work with our partners to seize the drug shipments and utilize tools that we have, sanctioning tools, including the Kingpin Act and the Magnitsky Act are very important tools that we could use. In Guatemala, we have supported the efforts of CSIG and the Attorney General to combat organized crime and corruption. They have made a lot of progress and have put dangerous criminals behind bars, corrupt politicians included. Now, it appears that CSIG and the Attorney General have become victims of their own success. They have faced threats, smear campaigns through troll banks that have began a campaign effort to discredit their work and attempts to undermine the work that they do. Mr. Olson, is it true that drug cartels and other criminal organizations commonly finance political campaigns in Central America? And are you aware of any instances where these illicit actors have attempted to directly interfere in elections by supporting disinformation campaigns or troll banks, as I started to call them?
Thank you, Mrs. Torres, Representative Torres. I appreciate your interest in your work in Guatemala and Central America, which is often overlooked as an important part of our region. And in answer to your question, absolutely. You mentioned CSIG. CSIG did a major report on money laundering and attempts to really, of the past president, who's currently in prison, of using his political party as a money laundering vehicle to run his campaign. And there's been evidence of other cases in Central America, in Mexico, often at a local level, where criminal organizations, not for ideological reasons, supporting a political party, but simply to gain access and guarantee their own impunity, use the weak campaign finance laws to manipulate and control the process. So for me, this is a little bit of the original sin for a lot of the people and governments in Latin America, where people use weak campaign finance laws to begin the process of corruption that later allows for the burgeoning of criminal organizations and drug trafficking. And there's no question that they use modern communication techniques to influence that process.
Mr. Semeski, I recently was made aware of a contract, a lobbying contract that Guatemala officials signed to lobby against CSIG and the Attorney General, to lobby members of Congress here. Since that contract, I guess, was discovered, it's been terminated. My office has inquired within our Attorney General's office to investigate the third-party payer, which I believe to be tied to illicit activities. What are our options there? And I believe I ran out of time. I hope that maybe you can write back an answer to what are some of the options that we can do to approach that. Thank you.
Thank you very much. I recognize the Congressman from Florida, Chairman Yoho.
Congratulations there, Colonel Cook, on your chairmanship. Good job. Appreciate you all being here. This is such an important hearing. I don't know where to start. You know, we've seen the war on drugs since the 90s, if not before, and we have spent trillions of dollars through foreign aid on the war on drugs. But as was mentioned here, the increased growth in Colombia, the increased growth of the poppy fields in Afghanistan, and then I'm reading in Mexico, cultivation of the opium poppy, the primary source of heroin in the United States, has also increased to satisfy the increasing demand of the Americans and the rest of the world. And according to U.S. estimates, Mexico has experienced an increase of more than double of its opium poppy cultivation from 12,000 hectares in 2011 to 28,000 in 2015. 28,000 hectares, if I do my math, it's probably close to 56,000, 60,000 acres in our southern neighbor. And, you know, I'd like to have some of your input. You know, the war on drugs and with the initiatives that we have done have gone after the kingpins. But we've seen the kingpins kind of morph, change the organizations. And one of the questions I want to ask, and just get your opinion, if we have a trading partner like Mexico in NAFTA, should we bring that into a trade negotiation and just say, you need to stop it? And I know that's not in the realm of this committee, and if you don't want to weigh in on it, that's okay. If you want to write me a written response, that would be okay. But I'd like to ask you just your opinion, because to do business with countries that are supplying a drug that has virtually no medicinal use, and it's creates the mayhem we see. What are your thoughts? If you want to start there, Mr. Semeski.
Congressman, first of all, let me reiterate that I'm not here as a representative of DEA.
Okay.
I'm here as a private citizen. I'm retired from
As a
DEA.
private citizen and
So-
probably a parent, maybe?
And a parent, and I agree with you completely. It should be part of any negotiations, but just as our demand reduction should be taken into account.
Well, that's something we have to deal with.
Exactly.
I mean, and we need to deal with that. And
I first got involved in narcotics investigations with the Organized Crime Drug Enforcement Task Force inception in 1983. And at that point, we were all told, just put your thumb in the dike.
right.
We're going to take care of this on the demand side.
Well, the dike is overflowing.
Exactly. Exactly.
Let me move on to something else, because this is something that's, you know, I've been in Congress 5 years now, and I've watched the development of the Iran nuclear deal, and I saw the billions of dollars being taken over there. Have you seen an increase in Hezbollah and or Iran in the South American or Central American areas? Anybody want to weigh in on that?
I do, sir.
That could be attributed to the increased cash flow.
I think that it can be, that the increased cash flow is helping
Sure.
but it is not the main driver. I think that the reason why you see an increased presence and activity in Latin America in conjunction with organized crime by Hezbollah is driven primarily by the fact that Hezbollah, since 2006, when it took a severe beating from Israel in the summer war the two sides had with each other, Hezbollah made a decision to shift a significant amount of its revenue sources from organized crime. And in this past decade, it has expanded dramatically to build a global empire, which, according to some sources at least that I have spoken to, may actually outweigh the contributions that come from Iran. So you have certainly an ascendant Iran with a lot more resources supporting Hezbollah. Hezbollah involved in significantly larger activities than it ever was. Its involvement in the war in Syria costs an enormous amount of money, and the necessity to build alternative sources to fund that.
All right, let me move on to something else, and I appreciate your input on that. We talked about how the drug cartels have morphed. What way is the transnational criminal organization adapted to avoid sanctions or minimize the Kingpin Designation effectiveness, and has the U.S. sanctions regime related to the related to Kingpin's designation kept pace with the changes in drug trafficking? And Mr. Hall, I want to specifically ask you, you mentioned the 50% rule. What would you recommend if you want to start off with those two questions?
Thank you. In terms of the 50% rule, I don't, and again, this just to clarify, when we were talking about this before, I don't have any problem with, and I don't want to limit OFAC's ability to identify sanctioned entities. What I'm talking about is putting the burden under strict liability on individual businesses to do that for OFAC. That's what I think is ineffective. So to answer your question, the 50% rule, as it applies to businesses, shouldn't exist. And I also think that it also illustrates why there should be a safe harbor that's an escape for strict liability.
Thank you. I'm over my time. Thank you, Mr. Chairman.
Thank you, sir. Our last member is the next manager of the New York Yankees,
Thank you.
Representative
I asked for Girardi to go.
I kind of figured that. So, no, we can't lose you here.
Chairman,
Congressman,
congratulations on your new appointment. I hope you keep Mr. Cetus in check.
He's bigger than me. I'll do the best I can.
I look forward to working with you and I'll be as well.
Thank you.
I did enjoy our Codell to Europe. I had a good time. Like so many communities across the country, the district that I represent has seen increases in prescription painkillers, heroin. It's really, particularly East Harlem, continues to have a major problem with drug trafficking, and the impact of the Kingpin Act is critical. It touches on my district and my neighborhood as well. Just recently, the Trump administration declared the opioid crisis a national public health emergency, but there was one tiny major issue with that announcement. It had no funding and no backing aside from the acknowledgement of the epidemic itself. As this relates to Latin America, of the Tier 1 Kingpin Designation, which means they represent the most significant threats and concern with drug trafficking, 65 out of the 110 Tier 1 designations are in the Western Hemisphere. So this committee must and will deal with that particular issue. To make matters worse, gangs in El Salvador, Honduras, Guatemala, and Nicaragua are profiting from these illicit drugs, and they are taking advantage of poor countries. Yet we saw that 2 days ago, the Trump administration pulled the TPS for Nicaragua and only briefly extended it for Honduras. I fear that the lack of funding and pulling TPS and its misguiding foreign policy direction by the Trump administration could further cause instability in the region. I am also concerned with human trafficking and drug trafficking in the Caribbean. That is why I've commissioned a GAO study to analyze the impact of the Caribbean Basin Security Initiative, CBSI, which has been one of the U.S. main vehicles for countering drug trafficking in that region. I think we need to be investing more funding. I look forward to sharing that study with my colleagues on this committee once it comes out. Mr. Semesky, do you think that the Treasury Department's Office of Foreign Assets Control should expand its designation program to target gangs such as MS-13, which operate in El Salvador, Honduras, Nicaragua, Mexico, and the United States? What is the role of the MS-13 type gangs with regards to kingpins and drug dealers in that region? Are they playing a more active role? Are they, we know they're very violent, and are they competing for territory? Or what's the status?
Excuse me, Congressman. I'm not an expert on the gangs. To the extent of my knowledge, and again, I'm not here representing DEA, the gangs form alliances. If you take the Sinaloa cartel as an example, their business model is not to try to overwhelm, but it's to partner. So when they partner with gangs in cities like Chicago, cities like New York, it leverages manpower for them, it expands their distribution network, and they are able to control the drugs in an area by using a gang. The gangs can be, to the extent that they can be connected with an already designated cartel, they could be brought under that designation very quickly. To the extent that they're designated themselves as kingpins, as long as they meet the criteria for the Kingpin Act, yes, they should be designated.
Anybody else want to weigh in on the role of the gangs in the regions of Central America?
Well, the work we've done has looked at exactly what you're saying, the role in the region, and primarily the gangs are focused on territorial control, controlling neighborhoods, controlling streets and barrios. I was in a community in Honduras in May, well-known community. There were 6 different groups, and people could go by and tell you which street was controlled by which group. Their business model, if you will, in those neighborhoods is primarily extortion, sale and resale of small amounts of marijuana or other kinds of drugs, but their reach and involvement in grand international trafficking of drugs is, I'm not saying it's non-existent, but it's not the same as when we think of big transnational organized crime groups like at one point the Zetas or Chapo Guzman's group out of Sinaloa. So I think it's important, it behooves us, I'm not saying one is good and the other is bad, it just behooves us to understand fully and carefully what phenomenon we're dealing with and then how to address it. Because they each require a response, they just may require different sorts of responses.
Thank you so much. Thank you, Mr. Chairman.
Thank you, sir. I believe that's the last of our members here. I just want to thank everybody. I want to thank the speakers here. I think you've given us a lot. I know the staffs are, I think they're going to talk about some of these things where we can, this is not the first hearing we're going to go down this on Kingpin, because particularly with international terrorism and some of these other organizations, it's just too important, too dangerous, and we're probably going to have more on this. And thank you for taking the time and sharing your expertise with us. It's greatly appreciated. With that in mind, this meeting is now adjourned.
Thank you, Mr. Chairman.